All right, then we will go on the record. The time is 6 o'clock. This is the hearing for Deschutes County file numbers 247-23161 CU, 247-21666 CU, 247-21834A, and 247-211-1062A, all of which relate to the applicant's request for approval of a personal use airstrip. This is on remand from the Court of Appeals and LUBA back to the county. My name is Tommy Brooks, and I am the hearings officer in this matter. Before we turn to the substance of tonight's hearing, I'm going to turn things over to Mr. Regini to describe how the hearing process will work.
Thank you, Hearings Officer Brooks. For the record, Anthony Regini, Principal Planner with the Community Development Department. I'm going to go ahead and share my screen, and we'll talk about hearing procedures, and then I'll turn it back over to Hearings Officer Brooks for his instructions. So again, we're going to start with an explanation of the hearing format and instructions delivered by both staff and Hearings Officer Brooks. That will follow with a staff report from me, and then we'll get into testimony. Order of testimony will be applicant first, and then persons in support, those in opposition, and finally those who are neutral to the application. The applicant will be afforded an opportunity for rebuttal. Staff will be given an opportunity for closing comments, and then, if necessary, we will begin discussion of an open record period. For tonight's hearing testimony, we're going to afford testimony first to those who are in person, and then those who are joining us remotely via Zoom. For those in person, staff and Zoom staff will call persons who want to testify one at a time, and I'll go over that in a minute. Please remember that before starting your testimony, we'll need you to state your first and last name along with your mailing address, and this is important so that you receive notice of any decision issued by Hearings Officer Brooks. The Hearings Officer may, at his discretion, institute testimony time limits. For in-person participants, if there are, at this point, there is no one in the audience, Hearings Officer Brooks, but if some do show up, then I will ask those in attendance in person if they wish to testify, and then I'll call you one at a time to the front of the room where I'll ask you to fill out a sign-in sheet and then begin your testimony. For remote participants, similar to the in-person participants, I'll ask you to raise your hand. In this case, because you're joining us via Zoom, if you're on a computer or smart device, we'll ask you to use the raise hand button, which should be the bottom center of your screen. If you're coming in via phone, we're going to ask you to use *9, which indicates to us that you're raising your hand. As a Zoom participant, you're either coming in as an attendee or panelist. As an attendee, you can watch the proceedings, and then as a panelist, we'll have you elevated so you can provide your testimony, and at that point, your audio and video will be recorded. So again, there are going to be multiple opportunities during the hearing tonight where either myself or Hearings Officer Brooks will ask you to raise your hand. If you're on a computer or smart device, use the raise hand button. If you're on your phone, use *9. For the hearing procedures, any written testimony can be submitted to me. If you're in the room, you can simply hand me your written materials. Alternatively, whether you're in person or on Zoom, you can email me your submittal, including any attachments, to my email address, which is on the screen. It's anthony.ragini, R-A-G-U-I-N-E, @deschutes.org. Because this is a hybrid format, if the internet connection is lost, if it's the county's internet connection, then we'd ask you to be patient. It'll take us a couple minutes to reconnect to the hearing, and so we'll ask you to wait a couple minutes before beginning to connect back in. If your own connection is lost, then connect back in as soon as you can. With regard to the hearing itself, both staff and the hearings officer are responsible for an orderly hearing. So what this means is that any behavior or testimony outbursts which are not appropriate to the hearing will be addressed by staff and the hearings officer, and you may be asked to be removed from the hearing. At this time, I'm going to ask if anyone has any objections to the hybrid format of the hearing. If yes, please press the raise hand button. Again, the bottom center of your screen if you're in Zoom, or *9 if you're on your phone. I will note, Hearings Officer Brooks, at this time there is no one in the room. And producer, do we see anybody raising their hand to object to the format? And no objections, Hearings Officer Brooks. And at this time, I'll turn it over to Hearings Officer Brooks, and I will stop my share screen.
Okay, thank you, Mr. Regini. This application is being considered through a quasi-judicial process. The point of that is that I will consider only the factual evidence that is in the record, and I will then apply those facts to any relevant provisions of the county's comprehensive plan and its land use regulations. The standards and applicable criteria relevant to the hearing were identified in the public notice announcing the hearing. I'll also note that the hearing included the scope of the remand proceeding. It is important that you direct all your testimony to the standards and applicable criteria within the scope of the remand. And if you believe a criterion applies that was not listed, or if you feel like the scope of the remand is not correct, you may address the criteria that aren't listed or what you believe is the scope of the criteria of the remand. Sorry. However, please explain why the criterion must apply or why you believe the scope of the remand is different, and do so with specificity so that other participants may respond and so that I can address that issue in my decision. The failure to raise an issue with enough detail to enable me or other participants to respond precludes your ability to appeal that issue to the Land Use Board of Appeals. Also, the failure to raise a constitutional or other issue relating to any proposed condition of approval, again, with enough detail that allows me to respond to that issue in my decision, precludes an action for damages in circuit court. As I noted, I am the county's hearings officer in this matter. In that role, my job is to be an impartial decision maker. Thus, while I have a contract with the county to serve in this role, I am obligated to remain impartial, and I do not represent the county's interests or the interests of any other participant. To that end, I'll state for the record that I do not have any relationship with the applicant. I'm not aware of any connections I may have to other participants in this proceeding that would prevent me from remaining impartial, and I do not have any ex parte contacts to disclose. I have communicated with staff, but only to discuss the particulars of today's hearing and not the substance of the application. Before we get started, I want to note again that, there's a request in the record by the applicant to limit testimony to only those who participated in the original proceeding. Section 2232.030A of the county's code does state in part that a remand proceeding is limited and that only those persons who were parties to the proceedings before the county are entitled to participate in the remand. That language is also prefaced with the phrase, unless state law requires otherwise. So based on that code section, I am going to limit testimony today to only those who were parties to the original proceeding. However, if there is someone here who plans to testify and did not participate in the original proceeding, I will give you the opportunity to explain why you think state law requires that you participate in the remand. So for everyone's sake, and so that if I don't know if that issue will come up, but if it does, I'm going to ask anyone who testifies after you state your name that you confirm that you were a party to the original proceeding so that I can address how to deal with your testimony at that time. It is my obligation to preside over the hearing in an efficient manner. So at this point, I think, Mr. Regini, we can figure out how many people have signed up to testify. It sounds like no one's in the hearing room, but I see several participants in the online. So if we could figure out how many actually plan to testify.
Absolutely. So if you're joining us via Zoom, if you would, as Susan Strauss just did, press the raise hand button to let us know if you wish to testify. I can relay that to Hearings Officer Brooks. Anyone else who wishes to testify, please press the raise hand button or *9. I don't think anybody's joining us via phone. So at this point, Hearings Officer Brooks, other than the applicant, we have Susan Strauss and Jennifer Bragar, who are both participants in the original application.
Okay. Thank you. With that, we're ready to turn to the testimony. But before we begin, does anyone wish to challenge my ability to hear this matter or to challenge the county's jurisdiction over this matter? And Ms. Strauss, I believe your hand might be raised originally from wanting to testify. So if you could, all right.
Yeah, Hearings Officer Brooks, it looks like no one is objecting to your ability to conduct the hearing.
All right, so with that, we will turn it back to you, Mr. Regini, for the staff report.
Thank you. I'm going to go and share my screen again. There we go. So the subject property consists of two tax lots. Tax lots 301 and 600. Tax lot 301 is addressed at 20925 Harper Road, and tax lot 600 is addressed at 20616 Harper Road. The site plan is unchanged from the application. So as noted in the application materials, and I'll talk about the dimensions of the airstrip a little bit later, it's proposed to be 75 feet in width by 2,000 feet in length, which is shown on the screen. The applicant does not propose any new structures as part of the airstrip, and no paving as part of the airstrip. I will also note that the airstrip, although it's not quite clear on this site plan, does span both tax lots. The land use history, just very briefly, there was some confusion. I talked to a member of the public today and also received an email where there may be some confusion regarding approval or denial of the airstrip. So I wanted to just briefly touch on that. The applicant in this case applied for a conditional use permit, and I don't recall the file numbers off the top of my head, and that application was denied. The applicant then reapplied for a conditional use permit based upon the issues raised by the hearings officer, in this case, Hearings Officer Brooks, and that file number is 247-21-000-666-CU. That approval by Hearings Officer Brooks was then appealed to the Land Use Board of Appeals and then to the Court of Appeals. Based upon those two decisions, the county's approval was then remanded back, in this case, to Hearings Officer Brooks. Very briefly, because I'm sure the applicant and others will address this, there are three primary issues on remand. Court of Appeals determined that additional findings needed to be made to determine whether or not the owner of the airstrip also controls the two aircraft that are proposed to be located or housed or used on the airstrip. The second issue is LUBA, in this case, asks that the county determine what is the geographic scope of the term surrounding properties, and this is specific to DCC 18128.015B, which asks the county to determine whether or not the use is compatible considering uses on surrounding properties. The third issue is related to surrounding properties in that both LUBA and the courts determined that the county should readdress compatibility of the proposed airstrip with respect to golden eagle nesting on surrounding properties. And specifically, the remand asked that we not essentially consider the ability of the applicant to secure a take permit from U.S. Fish and Wildlife, and then to also consider to what extent does the county's Goal 5 program have any bearing on the hearings, in this case, the hearings officer's decision on compatibility. As I mentioned, there were a couple issues that I wanted to talk about in addition to the remand. I will note that both the notice of public hearing and the staff report incorrectly reported the airstrip dimensions. Both the notice and staff report indicated the length of the airstrip would be 200 feet. And again, as I noted earlier, the length of the airstrip is proposed to be 2,000 feet. Hearings Officer Brooks did discuss the applicant's submittal of a letter with regard to who can participate in the remand. As of this point, based on the folks who have raised their hand, I believe Ms. Bragar and Ms. Strauss were parties to the prior proceeding and can participate. I will note for the record two things. One, Hearings Officer Brooks, I do have a list of parties, so if someone does show up who was not originally on the list, I can cross-reference names and addresses with the list of parties for the prior proceeding. The second thing, too, I also want to note is that among the comments that have been received by the county, we do have 3 comments from folks who were not parties to the prior proceeding. For this reason, they have not been included in the record. And so I wanted to make everyone aware in case there was an objection to the county's not including those comments in the record. And with that, staff is available for questions.
Okay, thank you, Mr. Reed. I don't have any questions for you. So we can move on to the applicant's presentation.
Producer, if we could please elevate Kenneth Katzeroff.
Good evening. Can you hear me?
We can.
Hear you just fine.
All right. For the record, Ken Katzeroff for the applicant. My address is 1420 Fifth Avenue, Suite 3400, Seattle, Washington, 98101. We're going the no tie route tonight, despite the fact that the hearings officer and Anthony has one on. Mostly because I moved last week and I have no idea where the hell they are. Sorry, where they are. In any event, I'm here tonight on behalf of the applicant. We think this remand's pretty simple. I submitted a couple of pre-hearing letters, including our legal position on this. With regards to the control issue, I'm hoping this hearing's really short. and I'm happy to answer any questions. But with regards to the control issue, we've resolved that issue. We have actually retitled the aircraft that were previously considered in the name of 20925 Harper Road. And so it's clear that they're that the applicant, which is that LLC, is in control because it's the same entity. And that's essentially what the Court of Appeals was looking at, and LUBA, although LUBA previously found that we were sufficient on that piece. What I would say is I also believe that there's already a condition of approval in the original decision that just requested any aircraft to be under control. And if the hearings officer determines that should be modified such that any aircraft that is actually based is similarly registered in the name of the LLC, applicant is certainly happy to do that. So I think that is really kind of a minimal issue in this remand. The larger issue may or may not be whether or not there's compatibility with Golden Eagles. I would say with regards to Mr. Regini's brief staff report, I don't think the issue is actually what surrounding properties is. What the Court of Appeals did, and then what LUBA's remand order after the Court of Appeals said was basically there needs to be some additional findings on whether or not the county's Goal 5 inventory resource of Golden Eagles has any bearing in the compatible use criterion. We submit that it does not. It's not considered. Case law is pretty clear on this. When you have a Goal 5 resource, it's not mapped on the property. The EC analysis itself specifically rejected providing additional protections against personal use airstrips. All this is in the record previously, as well as again in my new testimony letter. The last piece I would say about that is I really do think that this is a very narrow remand. What the Court of Appeals said on this issue was basically consistent with LUBA, that the regulatory scheme around a federal take permit is completely different than Deschutes County. And so we don't really need to deal with that issue. If in fact there is an issue with a federal regulation, that's a different process, and it doesn't need to be dealt with under the county's land use system and compatibility analysis. It's two different regulatory systems and should remain as such. We also made our Goal 5 argument and the county's interpretation of the compatibility criteria, not including wildlife, before the Court of Appeals. I'll just throw that out there. And I think that the Court of Appeals generally agreed with us. But on page 353 of that decision, they essentially said that the way they read LUBA's opinion, it concluded that the hearings officer, that LUBA sidestepped the issue and didn't address the Goal 5 and EC analysis argument. But because the hearings officer previously made findings about an incidental take permit, which is again separate regulatory system, that they cannot fault LUBA for asking the hearings officer to address the Goal 5 issue in the first instance. So again, it's our assertion that the hearings officer should look at the EC analysis, should look at the text of the compatibility use criteria, which does not include wildlife. And understand that the Goal 5 program is separate, did not choose to provide additional protections against private use airstrip, and it can't be overlaid on the property or this particular use. We've laid this out in our letter again. And so rather than reiterate myself for probably a fourth time tonight, I'll just say I'm happy to answer any questions you have. Otherwise, I would like to reserve whatever rebuttal may be necessary, if any.
All right, thank you. I think I do have one follow-up question based on your testimony tonight, and I may just not have been tracking what you were saying, but whether or not the decision needs to determine the geographic scope of the phrase surrounding properties. I thought you said that LUBA was not requiring that. It feels like they are based on the language in their decision, which I don't know that I initially see that the Court of Appeals changed that piece of it. So could you restate your argument there so I can understand what you're saying about whether or not
Sure.
how I address surrounding properties?
LUBA's instruction with regard to surrounding properties was predicated on whether or not Golden Eagles had any impact or consideration in the compatibility analysis to begin with. There's been assertions that there are mapped eagle nests, I don't remember how far, less than the protected area away from the subject property, and whether or not that should be considered. It's a tenet of Goal 5 and of Oregon law that if you're not mapped for a Goal 5 protection, you don't protect against it. This property isn't overlaid with mule deer. It's not overlaid with golden eagles. And what LUBA said was you should decide whether or not surrounding areas should, for some reason, also include the areas mapped for golden eagles. In this instance, what we're saying is that's not even necessary. Certainly, the hearings officer could say that surrounding properties includes, for a compatibility analysis, further than a mile. In this case, we would still be fine with regards to golden eagles, because if I recall, there's nothing mapped within a mile of the property either. Our point is that surrounding properties, the compatibility analysis from the get-go under the code does not include an analysis of wildlife. That's only done under the particular Goal 5 program and the program to achieve the Goal 5 issue, which in this case is the sensitive bird and mammal habitat, which reviewed in the EC analysis whether or not personal use airstrips warranted restriction in order to protect that resource, and specifically rejected that. So the issue of surrounding properties is really irrelevant, because the surrounding properties hook was in relation to golden eagles. And if in fact that's not part of the analysis when it comes to a compatibility and use analysis and the standard conditional use criteria, then it's irrelevant. But in reality, the hearings officer could say, hey, no, we look at a mile, or we look at 2, or we look at what's consistent with the farm impacts test, because that was a previous issue at this case. So it'd be reasonable to apply that same distance. But it doesn't matter when it comes to golden eagles, because they don't get additional protections. And in fact, case law says you cannot overlay Goal 5 protections on something that has been specifically rejected from protection. In this case, you can't find incompatible, it's our assertion, you cannot find incompatible the personal use airstrip use because of golden eagles, because the county's EC analysis specifically rejected providing additional protections. Does that answer your question?
I believe so. That helps me understand your position. Thank you. I don't have any other follow-up questions for you, Mr. Katsaroff, so of course you can come back up for rebuttal.
Thank you, sir.
So with that, I think we are at others in support of the application, if that's who the third person is.
Yeah, I don't believe so, but I'm going to ask the question anyways. Does anyone joining us via Zoom wish to testify in support of the application? If yes, please press the raise hand button. Seeing none, is there anyone joining us via Zoom who wishes to testify in objection to the application? If yes, please raise your hand. And we have Ms. Bragar, Ms. Strauss, Mr. Butler. And I didn't mention Mr. Butler earlier. He also was a party to the prior land use. I recognize the name. So we can take those in order here, Ms. Officer Brooks. Bragar, Strauss, Butler, in the order that they raise their hand. Okay. Producer, if you could elevate Ms. Bragar, that'd be great. And Jennifer, I feel like I'm always mispronouncing your name, your last name. And you're muted.
Yes, that seems to be a common error. It's Jennifer Breaker.
Breaker.
Share my screen here. And hearings officer, there's a light group of people here today, so I'd ask that you allow my client or me to represent my client for approximately 10 minutes to get through everything that I would like to present to you.
That's fine. I have not set time limits tonight, so I will only cut you off if it goes on and on and on.
Okay, so my name is Jennifer Breger and our office represents Annunziata Gould. My address is 121 Southwest Morrison Street, Suite 1850, Portland, Oregon 97204. This information is presented in continued opposition to the proposed private airport application to be located next to quiet use recreation areas and within 2 miles of Golden Eagle habitat. As a consummate environmentalist, Ms. Gould continues to be the voice of the voiceless golden eagles that will be adversely impacted if this application is approved, and as a surrounding property owner living at 19485 J.W. Brown Road, Bend, Oregon, she values the Golden Eagle experience on the BLM lands near the proposed private airport. On remand, the county must determine the geographic scope of the phrase surrounding properties in the compatibility standard and determine whether the proposed airport use is compatible with uses on the surrounding properties for golden eagle nesting without regard to the ability to obtain a take permit, and considering whether the county's program to achieve goal 5 with respect to golden eagles has any bearing on the determination. That's from the remand order on sub-opinion page 17. Any argument by the applicant that the golden eagle's use and habitat on surrounding property need not be considered is a ship that has sailed, because the LUBA and Court of Appeals decisions both require assessment of golden eagles and the impacts thereon. So the proposed private airport is incompatible with the local golden eagle nests located between 0.2 and 1.7 miles away from the subject property on the surrounding properties. And the county's program to achieve goal 5 is not dispositive as to the ability of the applicant to meet the separate compatibility standards under Deschutes County Code 18128.015B. The code neither defines the term surrounding, nor does it provide any limit to the scope of surrounding properties to a specific distance from a subject property. Scientific evidence, not the applicant's incomparable farm impacts test applied to a separate state standard, is what should inform the surrounding properties determination for the compatibility study standard under GCC 18128.015B. The geographic scope of surrounding property should be based on the evidence in the record that shows conflicts between the proposed private airport and existing and projected uses on surrounding properties. Relevant to this remand, the territorial range of golden eagles is a 2-mile radius from their nests, a radius recognized as significant by LUBA. Further, the 2-mile radius is established as the appropriate protective radius for golden eagle nests by the United States Fish and Wildlife Service pursuant to the Federal Bald and Golden Eagle Protection Act. Since the original hearings on this application, the county published its Wildlife Inventory Update Public Outreach Report, where the 2-mile radius is set forth specifically for golden eagles. In addition, the record contains substantial evidence that shows conflicting uses, like the private airport inside the 2-mile territorial range, can cause negative impacts to the golden eagles and their nests, including bird strikes, lead poisoning, and loud noises, as described in detail by Mr. Frank Isaacs and others. Other testimony in the record regarding the golden eagles include interference caused by loss of habitat and roosting locations, as well as disturbances caused by anthropogenic noise impacts. Further, the application's record provides context as to the compatibility of the proposed private airport with the 5 nearby golden eagle nests. In its testimony, the United States Fish and Wildlife Service states that the proposed private airport will likely cause disturbance to golden eagles. Land use impacts on even unused nests must be considered because, as stated by experts Kocher and Steenhoff, golden eagles will reuse nests even after decades of non-use. this corroborates Mr. Isaac's testimony. As a result, the geographic scope of the phrase surrounding property should be 2 miles from the subject property when evaluating the compatibility standard under 18-128-015B for golden eagle nesting uses on surrounding properties. The hearings officer has acknowledged that the use would conflict with local golden eagles because requiring a take permit as a condition of approval recognizes the conflict between the proposed use and the current golden eagle nesting that necessitates a take permit. On this record, the eagles and eagle nests cannot be protected from this private airport use, which is incompatible with the continued health and safety of golden eagles. The only way to protect the eagles is to deny the application because the other conditions of approval only raise questions as to scope and enforcement capability. Our letter submitted today provides a detailed explanation of why the county's program to achieve Goal 5 is not applicable. The sensitive bird and mammal habitat combining overlay adopted as the county's Goal 5 program to achieve Goal 5 could have bearing on this application if the overlay applied to the subject property. However, the subject property is not included in the overlay. Instead, the compatibility standard under 18-128-015B is the acknowledged regulation adopted to protect Goal 5 resources that could be affected by uses on land outside the overlay. DLCD acknowledged the approval of the code provision as well as the county's successive amendments of the provision. Therefore, the applicant cannot force a direct application of the Goal 5 program on a conditional use application that is not covered by the SBMHC. Applicant's effort is a thinly veiled attempt to read out the conditional use criterion under DCC 18-128-015B and treat it as surplusage by asking the hearings officer to consider the unrelated overlay that does not cover the subject property. Moreover, the applicant claims that the EC analysis found no conflicts with personal use airstrips, but this statement is false. Even the most cursory review of the EC findings expressly states personal use landing strips are a potential conflicting use for the jaguar nests located near the subject property. DCC 18-128-015B applies directly to this application as an acknowledged code provision, and the applicant cannot assert that the EC, or so-called program to achieve Goal 5, would have any direct or precedential bearing on this application. As described in detail earlier in my presentation and in the letter submitted today, the proposed private airport is incompatible with golden eagle nests surrounding the subject property and cannot be approved. The hearings officer should be aware that the applicant began construction of the proposed private airport prior to obtaining a final land use approval. The graded area depicted in this image is approximately 2,000 feet in length. This is the same length as listed in the Oregon Department of Aviation's letter of provisional approval from May 14, 2021. Under DCC 2220-015A, the county cannot approve any land use application if the property in question is in violation of applicable land use regulations and/or state law. Here, the applicant is not in compliance with multiple relevant land use regulations. Further, this remand action does not fall into any of the enumerated exceptions listed in the code, and because of impacts to golden eagle nests, cannot be approved. Moreover, according to the ODA, prior to any construction or establishment of the proposed airport, the applicant must submit an application for approval of the site to the ODA as described in ORS 836-090 and to pay application fees under 836-085. Further, the ODA has indicated that prior to the finalization of the provisional approval, the ODA was to do a final site visit, but none of the above has occurred. At this time, all construction on the subject property associated with the proposed private airport use must cease until the applicant brings itself into compliance with state law. The county cannot approve this application under DCC 2220-015 and its subsection D. Further, on denial of this application, mitigation must be mandated in order to bring the land back to its previously landscaped condition prior to unlawful construction activity. Finally, we have raised a notice issue in our written submittal, and this hearing should be continued until all parties are provided adequate, accurate, and fair notice. As has been consistently reiterated through the lengthy proceedings, of this application, a conditional use is not a use allowed by right to be rubber stamped just because the property owner decides to apply for one. Here, the application cannot be conditioned in a manner to meet the county code, comprehensive plan, or compatibility tests therein, and the use should be denied. The private airport has been shown throughout the process to be incompatible with the Golden Eagle and nesting locations within 2 miles of the subject property. This application should be denied because it cannot meet the required approval standards. Thank you.
Thanks, Ms. Brager. I think the one follow-up question I have for you, and maybe I missed something in a late filing, but what's the notice issue that you've raised?
That well, the notice was inaccurate as to the length, like Anthony said, but then there's also this requirement under DCC 2224 080B that states and describes who is considered a party during the initial proceedings. And it's any person who appeared on record or presented written evidence in conjunction with an administrative action or hearing shall have standing and shall be a party. And that those individuals are entitled to notice under 2234-030. And if you look at the notice list, you'll see that there's approximately 24 individuals listed on the county list that state no address was provided, but their email addresses were provided. And yet the same notice shows that some of the people that the county notified were provided only email notice. And so there should be a fair playing field here. And no one should be given priority to get email notice. And if you're going to email people and they provided you with an email, then they should have notice of this hearing. Thank you.
Thanks. And just one additional follow-up to that. Was there a submittal that from you or from your client that spelled that out? I was
Yes.
looking through the application or the materials, and I just want to make sure I can find that.
Anthony has those materials.
Hearings Officer Brooks, this afternoon, approximately 4:30 or so, 7 emails were submitted to the record. I'm not certain if they've all been uploaded. When I left the office to come to the hearings room at about 5:17, our administrative staff was in the process of converting those to PDFs and uploading them. So they may in fact be done now, but they were in the process of being uploaded prior to the hearing.
Okay, thank you. That answers my question. The last thing I have, I'm sure, wouldn't have had stuff from today on it. So I will keep a lookout for that. That's all I have for you, Ms. Brager. Thank you.
Thank you.
At this time, producer, if we can elevate Ms. Strauss.
Hello. I just want, before I begin to give my testimony, I just wanted to say that I've been involved in this from the very beginning, and I never received any email notice about this meeting. I learned of it only through a friend. So it's just for information. So I just like to begin by saying that our family has been a neighbor to this property in question since 1989. And we've walked the property. We knew the previous owners, walked through the whole area, and for many, many years, and enjoyed the wildlife. I want to also point out that around 1990, 91, somewhere in there, there were public hearings about these golden eagle nests. And Jim Anderson, who's now deceased, had created a map with all of the active and sometimes active nests of the golden eagles. And that was part of a hearing, and I don't know whatever happened to that map. But as far back as, I'd say 1990, 91, there were mappings of these golden eagle nests. There are many uses that we of the, quote, neighborhood, and also now visitors from all surrounding this area enjoy about this these BLM area tracts. In particular, Harper Road and the Maston Wildlife Conservation Area tracts honor the need of people and wildlife to have quiet uses of nature in certain places. This area, in particular, the Maston Wildlife Conservation Area, was specifically protected for its natural resource values, which includes protection of the golden eagle and prairie falcon. Their mating rituals, which need, as we've already heard, large space, and also their procreation, which can be easily impacted by low-flying aircraft, as well as the activity of many, many other wild creatures in the area. Specifically for this purpose, Deschutes County, BLM, LUBA have stated and documented specific protective language, which is part of the record, the current record, and the stated intention for all development in the surrounding area. As we and our neighbors have stated in previous hearings, there is no way that a private airport with low-flying planes can be compatible within feet of golden eagle nest sites along the Deschutes Canyon. And if you look at those maps, it's I wanted to say it's a stone's throw, but it's probably not a stone's throw. It's more like maybe an arrow's shot from where the airport would be constructed to where golden eagle nests exist. So well within the 2-mile protective radius. If such an airport were to be built, eagles will do 3 different possibilities will happen. Probably the first is that eagles will leave, or they may become injured. Their offspring could be easily injured, or some may be killed by interaction with flying aircraft, landing, taking off in that area. As I said before, the previous owners of this site, as well as many other of us in the neighborhood, have tracked the lives and enjoyed the beauty of these magnificent birds and their nest activities along the canyons of the Deschutes River. For years, these areas have provided quiet enjoyment of nature. In recent years, foot and bike and horse and associated car traffic to these areas has greatly increased. So much so that I have to search to find times when I might take my quiet walk undisturbed. I make my living as an author of wildlife material, and I walk regularly in these areas, looking for rare experiences with wildlife, who also are seeking undisturbed windows of time. Increases in Central Oregon's population will always stretch our intention to protect these areas. The Maston Wildlife Conservation Area is about 4,900 feet to the northeast of the proposed airport. This area is currently closed annually from February 1st to August 31st for the express purpose of, quote, protecting nesting golden eagles and prairie falcons, unquote. If hikers and bikers, bike riders, are considered a threat to golden eagles annually, how could a private air landing and takeoff strip be any less of a threat? The Deschutes County Wildlife Inventory Update Public Outreach Report from May 21st, 2021 states that the scientifically defined buffer distance for golden eagles is 2 miles. This is strengthened and supported by research interest from the U.S. Fish and Wildlife Service, and the proposed airport is well within this 2-mile area of the nesting sites, which could easily be within accident range. This airport is the personal desire of an individual. A private airport located 6 miles from the Roberts Field Redmond Airport and will provide 0 benefit to the county. There is no economic benefit to the citizens of Deschutes. no energy benefit, no social benefit. Yet there is great harm to all of us from the degradation of our established, protective county, state, and federal language that was hard earned for the benefit of our American wildlands and wildlife, which gives so many of us so much beyond measure in money or convenience. As a neighbor recently said to me, "What? We have to fight this again? I thought this was denied." I say, yes, please, deny this application again. Thank you.
Thank you, Ms. Strauss. I do not have any questions for you.
Okay.
Producer, if we could elevate Mr. John Butler. Mr. Butler, if you would unmute your microphone. There you are.
Okay, thank you. Yeah, my name is John Butler. I live at 5353 Southwest Loma Linda. I'm fortunate enough to live on the canyon, and I see golden eagles from my back window every day. My house is approximately a quarter mile from the northernmost nest site in the Maston Jaguar golden eagle breeding territory. When I heard about this, I went to Frank Isaac, who recently conducted a 10-year study of golden eagle nesting in the state of Oregon for the Bureau of Reclamation and, BLM and for U.S. Wildlife Service. And he gave me the position of a nest site, which is not currently being used, but potentially will be used in the future. That's 0.2 miles from the airfield. One thing that people don't know about golden eagles is that they have several nests in their breeding territory, and they occasionally move from one nest to the next. This could be due to disturbance, or it could be due to accumulation of feather lice, which makes the nest unusable for a period of time. So I just wanted to point out that there is a nest very, very close to that airfield, and it would definitely be impacted by the use of an aircraft that's louder than a locomotive. So that noise complaint was somehow dropped, but it's still a real complaint when you consider the effect it has on golden eagles. So that's all I had to contribute. I submitted my comments, and I also included in my comments a copy of a scientific article about nesting of golden eagles in Idaho. So I hope you will read that and learn something more about golden eagle biology. Thank you very much.
Thank you, Mr. Butler. I don't have any questions for you.
At this time, Hearings Officer Brooks, I don't see anyone else with their hands raised who wishes to provide testimony.
Okay, we can turn it back over to the applicant for rebuttal then.
Producer, if we could elevate Mr. Katzeroff.
I believe Alex Polvey actually wanted to address the ODA issue raised by Ms. Bragar. If we can raise him. I don't know if he can raise his hand or not.
He can. Producer, if we could elevate Mr. Polvey.
Hello. First, I just wanted to say thank you, everybody, for spending your time on this, including the opposition. I really appreciate you all getting involved. Regarding the ODA did come out and do a site visit, and they did issue final approval, and all permit fees were paid. And we've already submitted that to the record. And if not, I'm sure we can resubmit it again with our arguments. The other point I just wanted to raise, the record also contains flight counts over surrounding properties up to, I don't know how wide, I believe it was about 5 miles. And it shows thousands and thousands of flights per year over this area. So if opposition's already open to thousands and thousands of flights, and that's what they deem as quiet, this use should be de minimis from there.
I'll take it over from there then, unless you have any questions for Mr. Polvey.
I don't. You can proceed.
The record is an interesting question. I would ask staff what their preference is. In the past, there's been some questions about whether or not the record below before remand was specifically already included during the remand proceeding, or whether it needed to be specifically resubmitted. And so I'm hoping that we can address that before this evening's over, because I really don't want to send in thousands of pages for no reason. I wanted to hit a couple of things really quickly on rebuttal. And so again, I'm going to try to not take too much time here. I will first address the issue of that Ms. Bragar raised about DCC 2220.015 and this allegation that there's some sort of a state law or code violation on the property. There simply isn't. Mr. Polvey just addressed the ODA issue, but more specifically, DCC 2220.015 has been interpreted by the Board of County Commissioners, in fact, in a case that both myself and Jennifer were involved in. And how the board has interpreted is that provision is really not used unless there's been an adjudicated code enforcement issue, and there's simply not in this instance. As far as I understand it, there actually hasn't been any construction related to the proposed airstrip. Instead, there's been some normal mowing and whatnot of a non-productive field, or it's got alpaca, et cetera, but certainly no significant construction that would otherwise violate an approval that had recently been received by the county for a personal use airstrip. As the hearings officer, I'm sure, is aware, as long as we have local approval, we're entitled to rely upon it. And to the extent that has occurred, that doesn't create a code enforcement issue when there's a remand proceeding. We were entitled to rely upon it in the first instance, and we're good to go from there. The record does include information from the U.S. Fish and Wildlife, including that they didn't think a take permit was necessary. So I just want to clarify that. They visited the site, et cetera, and didn't say, oh, thou shalt get one. They said, we don't think it's necessary, but if you're worried about it, you can go ahead and get one. And so I think that's where a lot of the confusion happened during the first proceeding, was whether or not that ensured some sort of compatibility. And again, we would submit it simply doesn't. It's a completely separate regulatory system and really shouldn't be addressed. Ms. Bragar also stated that the EC analysis specifically did consider these a conflicting use, and that's not really quite accurate. When you're doing a Goal 5 analysis, and this is all spelled out in the OARs, and we're happy to provide additional briefing on it, and that we have in the past, but when you're doing a Goal 5 analysis, you identify any use that could potentially be a conflicting use, and then you're supposed to weigh them and then decide whether or not it's as a conflicting use that rises to a level, one of, I think, 3 or 4 tiers, that requires additional protections be placed against it in order to protect the Goal 5 resource, in this case, golden eagles. And during the EC analysis for the sensitive bird habitat, golden eagles, it was determined that no personal use airstrip were not conflicting enough such that additional protections were warranted. So this analysis has already been done. To the extent we want to get back at looking at what surrounding properties is, the applicant does get the benefit of the goalpost rule. And in this case, to the extent there is an issue with golden eagles, the protection zone that has been adopted by the county is mapped and has a surrounding property buffer of 1,340 feet, I think, quarter of a mile, which doesn't get anywhere close to this property for any mapped eagle. But again, I think the more important point here is when you actually look at what the code says and how it defines the criteria, the only place that folks have previously imputed wildlife is under the category of natural resources. But that is a specifically defined term in the code that looks at the property itself and the actual materials, the resources on the property, air, rock, etc., water. That's what the definition of the code says. It does not include wildlife, which makes sense. That's a completely different regulatory protection scheme under Goal 5. And again, there is a Court of Appeals decision on this, Johnson versus Crook County, I want to say, that we've cited in our letter, that says you cannot overlay protections that an EC analysis specifically rejected. And that was a case where they were looking at additional protections to, I think, the Metolius River and then groundwater that specifically rejected those protections, and they found you couldn't overlay them when they haven't been adopted by the county. So again, this is I really think this is kind of settled law, and we just got a little bit sideways in the previous decision, but we've outlined it here now. Last thing I would say, two things, sorry. Ms. Strauss seemed to want to make a larger compatibility issue. That's not really the issue on remand. It's outside of the scope. We're looking at compatibility with golden eagles, if that is even at issue. Again, we submit that it's not. Lastly, to the extent the hearings officer does in fact believe there's a notice issue, and I'm not having seen Ms. Bragger's letter or argument before, I have no idea. I don't know whether notice was incorrect or not. But to the extent the hearings officer determines that he's concerned with that issue, the applicant would consent to an open record period that would be the same period of time as a new notice to correct that issue, so that anybody who may want to submit written comment may do so. We don't want to have another oral testimony. I don't think that's necessary, but if folks want to submit testimony, if the hearings officer is concerned with that issue, we'll consent to that. Again, I would caveat that this is a remand process, and so the county has a tight clock, a maximum of 120 days that we cannot extend. And so to the extent there's any concern about wanting additional review or record times, that's potentially going to pose a timing concern. Just want to throw that out there. And I don't have anything else unless you have additional questions for me.
Thank you. I don't have, I guess, substantive questions for you, maybe more process questions. Trying to grapple with whether or not you're actually asking for the record to close tonight. I haven't read Ms. Brager's argument either about the notice provision, so I will confess I'm a little stumped on whether or not that will feed in, and I might ask staff some follow-up questions about if they've reviewed that and if they have comment.
Can I just, sorry, I don't know that there's specific notice provisions that apply, and I'm looking at the code, and I would have the same question. Maybe it's worth bringing Ms. Bragar up, but the way I understand the code and state law is that we've got really specific notice requirements for initial public hearing, and not so much for a hearing on remand. Yeah.
The other, I guess, the issue you've brought up about the time frame for the county to make a final decision. I think if I understood what you just said, is that it's not waivable. Is that your position under the state statute or under the county's code? Tell me more.
State statute. It's our position under state statute that the county has a maximum amount of decision of 120 days. There's no provision for waiving that, and I'm not aware of any case law that has provided an applicant to fully waive that timeline. I am under a traditional land use review clock, but not on a remand, and I don't think that it's necessary in this case. These issues are pretty well directed from the Court of Appeals in LUBA, let's say.
What is the Tell me why, and what is the remedy if the county does not make a decision within the 120 days? Is that a remedy of the applicant or a remedy of other participants?
I think it's the remedy of the applicant, just like it is with the mandamus clock.
And
Applicant typically owns the clock.
so if the applicant owns the remedy, you do not think that the applicant can waive that for a period of time?
I don't know the answer to that, and I'm speaking off the cuff without looking at the statute. So I would.
All right. Okay. Just why don't you stay, I guess, here? Let me first ask staff if you've had a chance to grapple with the notice issue and if you have a position on whether or not the notice was adequate and or if the hearing needs to be renoticed.
Yeah, that's a great question. As I understand Ms. Breger's question or issue that she's raised, it's that our procedures ordinance requires notice to be mailed, and that's pretty specific. And we have taken mailed, the word mailed, to mean snail mail, not email. And what Ms. Breger addresses is the fact that the county provided electronic notice to Oregon Department of Aviation and U.S. Fish and Wildlife, along with, frankly, a couple of other agencies, but we did not provide electronic notice to those parties that provided only an email address. And so what I believe she's addressing is the fairness issue of the county's willingness to provide notice electronically to agencies but not individuals. If I'm understanding her, I'm reading her cover letter as we speak, and I believe that's the issue she's raised. With respect to the county's position at this point, I would need to consult with county counsel. And so I am requesting an open record period, not a specific amount of time to speak to Mr. Katzeroff's concern regarding how much time, but I'll need to consult with county counsel to provide a response to the hearings officer.
All right. And since we do have a kind of a small group here tonight, I'm going to go outside a little bit of the norm. And Ms. Breger, if you are okay and available, I would like to, I heard your initial response to my question about the alleged failure in the notice. But I still don't have the written, for, what you submitted in writing. Would you possibly be willing to readdress that issue so I just can, and maybe based on to what you heard from Mr. Katzeroff and from staff?
And Ms. Breger is raising her hand, so if we could have the producer elevate Ms. Breger.
Right.
And Jennifer, I apologize if I didn't summarize your concern correctly.
Thank you, hearings officer, and Anthony. I think that Mr. Regini did generally capture what we're talking about here. There's goal one. There's this process of the county shooting ahead in electronic worlds. This record contained at first testimony from Susan Hart. There was a submittal by the opponent or the applicant's counsel saying that she shouldn't be included in, her testimony shouldn't be included because she wasn't a party. You ruled on that, but before you ruled on it, suddenly the materials disappeared from the website before you ruled. So staff is making all these sort of unbalanced decisions throughout this process that cause confusion.
So sorry to cut you off. My question is about the notice piece, and I'm wondering, what I'm trying to focus in on is your argument that the notice was insufficient, and therefore I think what I heard in your original testimony was that this whole hearing should be re-noticed. So in light of staff's kind of initial response that the code section that you cited to requires mailed notice, I guess I want to know if I'm getting your position correct, that you feel that the notice was inadequate under the county's code to the extent that it was not emailed to some of the prior participants.
Yes, and an even playing field mailed notice under the county's process. What they're actually doing is emailing some notice out. And so those agencies got notice, but the people, the parties, the individuals did not get notice in the same manner. So therefore, there's a violation of the county code. I'm also not seeing anything in the state law, at least quickly, related to 120 days for a remand. So as Mr. Katsaroff continues to suggest that there's certain rules in place, unless he cites to them, I don't think that's a reliable statement.
Okay. All right. Thank you for coming back up. I appreciate you clarifying some of your position. I'm going to, I think I'll conclude my questions there. I guess as per usual, I'm going to turn it back to Mr. Regini just to see if there's anything else that staff would like to add before I close the testimony portion of this.
Thank you, Hearings Officer Brooks. Just two things I wanted to note, really for all parties. Received a number, actually maybe a number is too strong a statement, a handful of emails today. So again, as I noted, admin staff was busy trying to get those converted and uploaded as I was proceeding over here to the hearings room. I'm hoping and I'm expecting all of those submittals that were received today to be into the record and up on the website. So in case anybody is wondering or wants to be able to see it, they should be on there tonight. Second thing I wanted to talk about is Mr. Katsaroff raised the issue of whether or not the prior record is part of this record. And so when we received the application for the remand, I consulted with County Council, and what we decided to do, which seemed to make the most sense to us and certainly open to any suggestions otherwise, when we created the website. So again, to explain for anybody watching or all the parties, the county's record for this application is the record as it appears on the website that was created. So what we did on this website is put a link to the prior website, which contains all of those materials. And so we felt, again, Planning Division in consultation with Legal Counsel felt that that was an adequate way to present the entirety of what we consider the record before the hearings officer for this particular proceeding.
Thank you.
And then, as I noted earlier, I would request that the record be left open. I think I'll need to consult with County Council on the notice issue and possibly put a staff memo into the record. I will note that both Ms. Brigger and Mr. Polvey have raised their hands. I don't know if the hearings officer wants to entertain questions.
I actually will, and we'll start with Ms. Brager. I will give the applicant the chance to respond to that.
Okay. Producer, if we could elevate Ms. Brager.
Thanks, Officer Brooks. Thank you. I just want to preserve, based on what Mr. Regini just described as having received additional emails today, that we, as parties, have a right to rebut information coming in. So it sounds like there's going to be an open record period, but I just want to preserve our right to respond to anything new that's come in. Thank you.
Thank you. And Mr. Katsaroff.
Yeah, I think Mr. Polvey wants to chat, but the one thing that, while maybe potentially we raise him, I can handle the remand question and the time limit. ORS 215-435 is the remand statute, and unlike the clock, it provides one exception, and it specifically states that the only exception to the 120-day clock is if the parties enter into mediation as provided under ORS 197-860. And so I think that any normal read of the statute would say this is the deadline and there's one exception. So I know there's been some consternation actually over the 150-day clock and whether or not that can be waived. And there's one decision that I'm aware of that the Court of Appeals has said, okay, but nobody's really raising it, and we're actually not getting to the question of whether or not you can file a mandamus. In this case, I think, this statute's a lot more clear. It says this is the deadline, and there's one exception. I can't imagine that the parties in this case are going to enter into mediation knowing who the parties are, so I would just say that that's unlikely.
Okay. I think, I don't know if I want to open it back to anyone else. I understand you said Mr. Polvey might want to speak, but if it's not about we're really discussing process right now. So if it's not about the process, I'd like to move on.
Mr. Polvey, if you have something to add regarding process, what I understand is the hearings officer, we can elevate you, but if it's not about the process, Mr. Polvey is, well, Mr. Polvey, you raised, unraised, and then raised. So do you have something to add regarding process? Keep your hand raised if so. And it's remaining raised. Do you want me to have him elevated?
Yes, please.
Okay. Producer, if we could elevate Mr. Polvey. Thank you.
Yes. Oh, all right. Sun's going down here. Thank you. I just wanted to point out, as we were talking about the record and the previous record being combined, that in the example of the Fish and Wildlife U.S. Fish and Wildlife testimony that Ms. Brager offered, that was from the first record, and they came and visited the site, and then determined it wasn't going to be an impact, so then didn't offer any testimony in the second record. So while the first record included that was before they had a site visit. So I just wanted to recognize that even though it's all included in one, there is nuance to like how it has unfolded.
Thank you for that clarification. All right. With that, then we'll conclude all of the testimony and sort of chart a path forward here. I do think that there's just enough here that we probably ought to have an open record period. I would like to have a short one in light of the time frame. I think it would be nice if there was a clear path for the applicant to be able to extend that, but it sounds like I probably agree that it's would be an issue of a matter of first impression. So rather than try to do that, let's try to stick within the current deadline that goes in from the date of the request for the proceedings. At the same time, I think Ms. Brager's right. I mean, if there's new information that's presented, and that parties should have the right to respond to that. So I'm going to do a relatively shorter sort of open record and response period. This is not the initial evidentiary hearing, so there's no entitlement to, 7 days. But let me look at my calendar real quick, just so I don't miss any dates. Sorry, this will take just a second. So today's the 11th. What I would like to do is, even though it's not much different, I would like to keep the record open for 6 days, which takes us to the 17th of April. Then with the opportunity, if there is new evidence presented during that time period, that the sort of rebuttal period be open until the 21st, which is 4 more days, so that we get all of this wrapped up in the next 10 days. And during that time period, during the initial time period, any participant, and by that definition is someone who participated in the underlying original proceeding here, can submit evidence, and then the rebuttal would be only to that any new evidence at that time. I don't think there, and I'll let Mr. Katzeroff speak in a second. I don't think there's any entitlement to a final legal argument that can be submitted with the rebuttal, and that we would be able to close the record at that time on the 21st. But Mr. Katzeroff, I did see your hand up, so if you'd like to address that, you can.
I think I'm fine doing final legal argument potentially at the same time as rebuttal. I think that's highly unusual. Never done that before. We've always had an opportunity to do it if any record period is granted. I'm not sure how that works with county code, but I think it says if a record's included, that applicant shall receive final legal argument. So I highlight that. In any event, whether or not final legal argument happens at the same time as rebuttal, I would request that it not occur on the 21st and at least roll over to the 24th. The reason being that I have a response to 5 different LUBA briefs due on the 21st. And so I think it's just, I would request that at least roll over to that Monday. But again, I think that the county's code actually mandates that if there is a record period, that there is a final legal argument.
Do you have a citation for that that's specific to the remand proceeding?
The remand proceedings specifically incorporate the regular procedures under DCC Chapter 2224. And what it says is, if the hearing is left open in accordance with DCC 22140, sorry, doing this at the fly, as I'm sure Mr. Regini is doing also.
Well, I'll just maybe head that off a little bit. I know that DCC 2224 is incorporated into the remand proceedings, but it says only to the extent that such procedures are applicable to remand proceedings under state law. And again, the final legal argument within state law applies to the initial evidentiary hearing, unless you have a different read on that.
I'm fine consenting and not creating any sort of a procedural issue as long as we roll it over till Monday the 24th and not have it be the 21st at the same date as those other due dates.
Okay, that's a fair position. What I want to avoid is having a rebuttal period that's longer than the initial period. So what I'm going to do then is change that open record period to the 18th, and then have the rebuttal period be through the 24th, which would include your opportunity to submit a final legal argument.
Thank you.
Mr. Regini, are you capturing this? I'll want to repeat it, but I know that you have other instructions you'd like to give.
Yeah, I believe I've captured it, and I've been able to, as you and Mr. Kasseroff were talking, to update my PowerPoint so I can actually even put it on the screen. So I think I have all the dates.
And just because this is outside the norm, and I don't want to get into a discussion about it, but if there are any objections to what I've initially laid out of a open record period until the 18th and a rebuttal period until the 24th, I'd like to hear from participants if there's an objection.
No one is raising their hand.
Okay. So with that, Mr. Regini, do you want to try to...
Mr. Polvey's raising his hand. We
should elevate him so I can find
out.
Yeah,
it's if we could elevate Mr. Polvey.
Sorry, Ken, not trying to go rogue on you at all here. Because we're doing this all on the fly, I just want to make sure I understand it before we proceed, because I haven't had a chance to actually talk to my attorney about all this. In the situation where if we're doing final legal argument during the rebuttal period, if there's something in the rebuttal period we need to talk to in our final legal argument, or do we have a chance to do that?
I understand the concern. Rebuttal is rebuttal. There's no right to serve rebuttal. It's all argument. It's again, I think if we were in an initial evidentiary hearing, you would have the ability to do that. But in light of the short time period here and being able to get to a close of this in time to allow the local process to go, and in the absence of an entitlement to have a final legal argument, I'm just going to keep it open for the open record and then a rebuttal period, and then it'll be up to the parties to decide whether or not they want to include legal argument in that and how they do that.
Okay, so you're saying in this case there is no entitlement to the final argument, final legal argument, and you're just not offering one.
Correct.
Okay, thank you for helping me understand that.
All right. And since there were no objections raised, we'll proceed with that, Mr. Regini. If you need me to restate anything before I provide a summary, please let me know.
Sure. So I'm going to go ahead and share my screen again. I just have 2 slides talking about the open record period. A couple of cautions that we like to provide as part of the open record period. Please be aware that the county is not responsible for retrieving information from a website or a cloud storage device. So therefore, what this means for you as a party submitting information to the record is you need to provide whatever information you want the hearings officer to consider. So again, we will not retrieve information. If you're submitting as a hard copy, you can send that to my attention. Again, Anthony Regini, Principal Planner. We really like emails. If you send it via email, you can send it to my email address, which is on the screen, anthony.regini@deschutes.org. And please remember, all submittals, regardless of hard copy or email, must be received by 4 p.m. on the deadline date. This is really, really important, particularly for emails, because we have had issues in the past where parties have thought that they submitted or hit send prior to 4 p.m., only for the county server to not have received it until after 4 p.m. So what I always caution people to do is please, please, please send it early. Don't wait till the last minute, 3:59. And then with regard to the open record period, and Hearings Officer Brooks, you can correct me if I'm wrong, what I heard is that new evidence and testimony will be due by Tuesday, April 18th at 4 p.m. And then in this case, it's rebuttal, evidence, testimony, and final legal argument, if any, by the applicant for final legal Monday, April 24th at 4 p.m.
That is correct.
And I will stop share at this point.
All right, I think that covers it. We will close the hearing. The record will remain open as just outlined by Mr. Regini, and we will go off the record at 7:23.
Thank you, everyone.
Thank you, everyone.